Havi.
Thank you, my Lord. My Lord, the motion dated 19th July 2021 is opposed by the respondents. My Lord, but before we go to the opposition, it is appropriate that we elaborate the orders as sought in the motion as they compare with the relief sought in the petition. My Lord, this is so because these orders in the motion are sought pending the hearing and determination of the petition. My Lord, the petition itself is dated the 19th of July, and prayer number 1 and 2 are declarations. But fundamental are declaration number 2, 3, and 4. My Lord, the effect of those declarations are twofold. One is to declare as illegal the Council of the Law Society of Kenya as composed of the 1st to the 12th respondent. The challenge upon which that relief is founded is against the decision made by members of the Law Society at the special general meeting held on 26th of June 2021.
What date in June?
On 26th of June 2021. It is as a result of that resolution that the Council of the Law Society of Kenya is constituted of the 1st to the 12th respondent. But Lord, it's also as a result of that resolution that the second interested party was sent on compulsory leave and the 3rd to the 10th interested parties were removed as council members of the Law Society.
Yeah.
My Lord, it is admitted that there is pending before the High Court in Nakuru petition number E017 of 2021 where all resolutions made at the meeting of 26th of June 2021 have been challenged. My Lord, the second aspect of the relief sought in this petition is contained in prayer number 5 and prayer number 9 of the petition. My Lord, in summary, the petitioner seeks to quash, through an order of certiorari, the letter dated 9th July 2021, summarily dismissing her. Similarly, my Lord, the petitioner seeks compensation for the violation of her rights arising from the summary dismissal. My Lord, what then is the nature of the relief sought pending the hearing and determination of the petition? The interim relief is threefold. First, an order is sought to stay the summary dismissal contained in the letter of 9th July 2021. Secondly, my Lord, an order is sought to stay a notice dated 13th July 2021, published in the Daily Nation, inviting applications for the office previously held by the petitioner. Third and last, my Lord, an order is sought to restrain the first and second respondents, that is myself and my vice president, from recruiting an officer in the office previously held by the petitioner. My Lord, in our understanding, the grounds upon which this interim relief are sought, as gleaned from the grounds on the face of the motion and the affidavit, are as follows. My Lord, the first ground is that the petitioner is not answerable to the Council of the Law Society, its individual council members, the vice president or the president. My Lord, if the words of the petitioner contained both in the motion and the affidavit she is only answerable to the Secretary of the Law Society of Kenya and nobody.
Yes.
My Lord, the second ground upon which relief is sought is that the summary dismissal was unlawful for the reason that it was not preceded with notice or a hearing.
Yes.
Lord, the third and the last ground upon which relief is sought is that the dismissal of the petitioner is an exclusive function of the staff, Budget and Finance Committee, and for that reason, the Council of the Law Society of Kenya cannot summarily dismiss her. My Lord, before I submit on the three principles upon which an injunction may be granted or refused, permit me to set out the facts in brief as they pertain to this matter. My Lord, at all material times, the petitioner was the Deputy Secretary of the Law Society of Kenya. My Lord, deputy to who? The office of the Secretary is created under Section 26 of the Law Society of Kenya. So she was the deputy to the holder of the office of Secretary under Section 26. My Lord, the operative letter of retention to that effect is dated 9th May 2016 and appears at page 9 of the replying affidavit of my Vice President, Caroline Kamende Daudi. My Lord, attached to that letter of retention is a contract appearing at pages 10 all the way to page 14 and signed on the 18th of May 2016. Again, the contract of service designates the petitioner as Deputy Secretary. Let me see. Am I dropped? Oh. Give me the microphone so that I can be able to talk to the judge.
Mr. Havi,
My Lord, I don't know whether you can hear me.
I disappeared briefly.
Oh, sorry.
For some interruption.
Okay.
The last word I had from you in relation to the submissions you're making
Yes.
is after the contract, which appears at pages 10 to 14, which was signed in May 2016, you said the contract designates, and then you went off. So if you could read from there.
Sorry, my Lord. My Lord, the contract designates the petitioner as Deputy Secretary.
Yes.
My Lord, significant are clauses 5, 6, and 7 of the contract of service. My Lord, it is admitted that under clause 5, subtitled Chain of Command, the Deputy Secretary is answerable to the Secretary. That's not disputed. It's a chain of command. My Lord, under clause 6, subtitled Discipline, if I may read, commencing with the second line, in discipline and insubordination shall result in summary dismissal. And the clause proceeds further. Any act of indiscipline covered under Section 17 of the Employment Act shall lead to summary dismissal. My Lord, the grounds upon which summary dismissal may be effected are enumerated under clause 7. And the conclusion under clause 7 reads as follows. Then, in each and every case, the Law Society of Kenya may summarily dismiss you without notice or payment in lieu of notice. My Lord, I pause and assert that the act of summary dismissal is a function of the Law Society of Kenya, as expressed from a reading of the contract of service itself. My Lord, I also submit that Section 44 of the Employment Act on summary dismissal also applies in this case. My Lord, what were the circumstances under which the petitioner was summarily dismissed? This is the sequence. My Lord, subsequent to the resolution of 26th of June 2021, the second interested party was sent on compulsory leave with pay. That was a decision of members of the Law Society of Kenya and not Nelson Havi, Caroline Kamende, or any of the respondents. My Lord, you will find at page 80 a letter dated the 28th of June 2021, duly received by the second interested party. My Lord, it is imperative that we set out the ultimate direction given in that letter. It read as follows: please therefore hand over all society's stores in your custody with a detailed handover report to your immediate deputy. My Lord, the immediate deputy of the second interested party was the petitioner. The next step is that on the 9th of July 2021, a meeting of the council was held at the boardroom of the Law Society in Gitanga Road. My Lord, the petitioner, as the second in command in the Secretariat, was called into the boardroom and asked to do three things. One, to dispatch two statements through the official email address of the society. Two, to avail the documentation necessary for the conduct of the council meeting. And three, to take minutes of the council meeting. My Lord, the petitioner took the position that she will not comply with any of those three sets of instructions. The petitioner was categorical that she does not take orders from anybody but the second interested party. My Lord, the petitioner proceeded to give the respondents a document dated the 26th of June 2021, which your Lordship will find at page 138 to page 139. That document is indicated to have been signed by the third to the ninth interested parties. The document purports to rubbish all resolutions made on the 26th of June 2021. The petitioner concluded that there being a conflict of instructions, one set from the second interested party and another from the respondents, she was obliged to disobey the instructions of the respondents. My Lord, was the petitioner heard on the issue of compliance with those three instructions? My Lord, you will find immediately after that document at page 139, at page 140, my Lord, the individual appearing as Wangira is the one bringing noise. If it could be muted. Wangira, I think.
He's now quiet because he's out of the meeting.
Thank you, my Lord. My Lord, if you look at page 140, is an email sent by myself at 12:44 p.m. to the petitioner and copied to the Vice President. The email minutes what has transpired immediately before it's written, and it reiterates the instructions to the petitioner. The petitioner has taken the position deceitfully that she never received this email. My Lord, if I may take you to the petitioner's affidavit, in particular at paragraph 38, this is what the petitioner says. That the respondents threw various questions at me, went ahead to intimidate me by quoting Section 44 of the Employment Act and threatening to dismiss me there and there if I refuse to sit in the meeting or take minutes of what they called caretaker council meeting. My Lord, assuming that she was intimidated, she confirms, assuming without agreeing that she was intimidated, she confirms Section 44 was read to her. And she was told she will be summarily dismissed if she does not comply. Then, my Lord, there is this recital that continues being made, that actions are being taken diabolically, unilaterally by myself. Is that the case? My Lord, the decision to summarily dismiss the petitioner is contained in minutes of the council, which your lordship will find at page 142 to 145. My Lord, as we speak, the office formerly occupied by the petitioner has been competitively filled and a retention made in terms of the letter dated the 23rd of July 2021. My Lord, you will find this letter at page 151 to 152.
Yes.
My Lord, let me now apply the principles for the grant of an injunction. And the starting point will be the celebrated case of Giela versus Casper Brown and Company Limited. My Lord, although many people refer to this case, little is ever said of the fact that this case related to an employment contract. Only that the claimant in that case was the employer. My Lord, I propose to pick the principles as they are set out in that case, and you will find them at page 3 of my listed bundle. Page 3. My Lord, the applicant must demonstrate a prima facie case with a probability of success. My Lord, what is a prima facie case with a probability of success? First, it must be a case anchored on a right given in law or equity. And second, the suitor, the claimant, must demonstrate that between his or her case and the response, there is more weight in his or her case and less in the response. After meeting that first threshold, the suitor or claimant must prove that the injury threatened cannot be compensated with an award of money. And my Lord, lastly, if the court is in doubt of the first two requirements, then the court may determine the issue on a balance of probabilities. Sorry, on a balance of convenience. My Lord, the second decision on the principles for the grant of an injunction in the Court of Appeal case of Nguruman Limited versus Jen Bonde Nielsen is reported as 2014 EKLR. And my Lord, this case illuminates the light on the sequential nature of the three principles. You must prove the first requirement first. You must prove the second requirement second before the court grants an injunction on the basis of the first two requirements or considers to act on the balance of convenience. To use the word of the Court of Appeal as set out at page 13, the existence of a prima facie case does not permit leapfrogging by the applicant to injunction directly without crossing the other hurdles between. There is no leapfrogging. It is sequential. My Lord, with those clear principles, the question is asked about the three main points upon which a prima facie case is claimed by the petitioner. My Lord, starting with the first issue, the petitioner proceeds from the premise that she cannot take orders from the council, the president, or the vice president. She will only take orders from the secretary. My Lord, I will pick two derivatives from that position. One, the petitioner received the three sets of instructions. And two, the petitioner said she will not follow those instructions. The court must therefore ask whether there is a prima facie case in the petitioner's claim that she's only subordinate to the secretary. My Lord, to enable you evaluate the prima facie nature of that claim, I will put three propositions. One, the secretary herself is subordinate to the council. In fact, the letter of employment of the secretary is signed by the president. Of course, with the recommendation of the council. The letter of termination of the secretary will be signed by the president, of course, on recommendation of the council. My Lord, the second proposition is this. The second interested party has been sent on compulsory leave as to whether or not that action is valid is for determination in a different forum, not this forum. It follows, therefore, that the petitioner as the second in command is subordinate to the council. And that is the case irrespective of whether the petitioner perceives that the council is constituted of strangers. I say so because the validity of that challenged council is for another forum, and that decision has not been set aside. My Lord, the second point upon which a prima facie case is argued is the claim that the petitioner was not heard. There was no notice or a hearing. My Lord, what is summary dismissal? It is instantaneous termination. It is based upon an act by the employee considered so egregious that the termination of the relationship should not be adjourned further. It's just that. Summary. But my Lord, notwithstanding the summary nature of that termination, the petitioner was engaged for over 1 hour. She retrieved a contract of service. She was taken through it. She was taken through Section 44 of the Employment Act. She says she was intimidated. Yes, let's assume she was intimidated. Some people intimidated her if she so claims. A claim that is without foundation. But the fact of the matter is, pleas were made to her. To cap it all, an email was written to her. She said she needed 20 minutes to consult. After 20 minutes, she left her place of work, put off her phone. My Lord, the right to be heard has two elements. It is given and it must be taken. And how you take it determines your fate. My Lord, one day, if I get a little bit old, I'll want to be a judge. Figure out this scenario. Me sitting as a judge, telling the deputy registrar in Milimani to transmit an order And the deputy registrar tells me, I don't take orders from you, my Lord Nelson Harvey. I only take orders from the registrar of the High Court and the chief registrar of the judiciary. I mean, what an absurdity. My Lord, this is important because there are some of our members who do not want the Law Society to work because of insubordination. It's as simple as that. Somebody says she will not comply with an instruction from the president or the vice president or the council, and the court will not countenance this insubordination. My Lord, the third point upon which a prima facie case is laid by the petitioner is reliance upon the Staff, Budget and Finance Committee. My Lord, indeed it is true that there exists the Staff, Budget and Finance Committee. As a matter of custom and practice, that committee is chaired by the Vice President. My Lord, what is a committee really? A committee is a non-legal congregation of people that performs in a delegate way the functions of a principal legal entity. The principal legal entity in this case is the Law Society of Kenya. And then the Law Society of Kenya has elected representatives who constitute the council. And what is the function of committees, my Lord? You will find this in section 40 of the Law Society of Kenya Act, number 21 of 2014. Permit me to read, my Lord. The council may establish such thematic committees comprising members of the society for the purpose of assisting the society perform or to advise the society on any matter relating to the performance of its functions. Without prejudice to the generality of subsection 1, there shall be a standing committee of the society to be known as the Budget and Finance Committee. So this staff committee is a delegate at the third level of the Law Society. My Lord, it's straight law that what can be done by the delegate may be done by the principal. I'll give you an example. Senate, as a plenary, may consider the question of impeachment of a governor. It may at the same time delegate that duty to a committee. Let me bring it nearer home. Judicial Service Commission is comprised of several commissioners. It can perform a function by itself or through a committee. My Lord, let me not argue from the air, because none of us knows the law, but where to find the law. Where from do I support my legal argument? My Lord, permit me to refer the court to the book by Gower and Davis, Principles of Modern Company Law. I've extracted that chapter. It is titled Default Powers. And my Lord, without taking so much of your time, what arises out of this text is that which is done by a delegate may be done by the principal. And there is case law to support that premise. My Lord, that is the decision in Barron versus Porter. Barron versus Porter. It's reported as 1914, 1 Chancery, 895. Same principle is elucidated. My Lord, the petitioner asserts that she ought to be processed, she ought to have been taken through the disciplinary process through the Staff and Finance Committee in an action initiated by the second interested party. My Lord, we have already seen the second interested party is on compulsory leave, a fact known to the petitioner. Again, we have demonstrated that the existence of that committee does not preclude the council from acting as the principal. My Lord, but fundamentally, is there a difference between the HR manual on one hand and clause 7 of the contract of service as read together with section 44 of the Employment Act on the other hand? Let us see. My Lord, the manual has been reproduced by the petitioner, but what is of relevance is what is at page 103. That is clause 13.6, dismissal. And then at clause 13.7, the subsequent page, summary dismissal. My Lord, even the HR manual sets the dichotomy between dismissal and summary dismissal. Under 13.7, summary dismissal may be effected only on the grounds set out in section 44. But more importantly, even under the contract of service, the act of summary dismissal is not an act of the committee or the secretary. It is a function of the Law Society, acting through its governing entity, the council. My Lord, I dare say the staff committee only recommends. The council can accept or refuse the recommendation, just as the plenary of the Senate can accept or refuse the recommendation of a committee. My Lord, I've demonstrated, in my humble view, with weight heavier than the claim of the petitioner, that there exists no prima facie case with a probability of success on any or all the three grounds upon which that claim is made. My Lord, what about the second principle? In fact, this is a petitioner who is leapfrogging. She has not even pleaded that money will not adequately compensate her summary dismissal. And my Lord, connivingly, she has not even sued her employer, the Law Society of Kenya. She has sued the president and the vice president. Was it that she wanted to show that we are impecunious, that we cannot pay her damages? But no, the mischief there is quite evident. And it doesn't stop there. The petitioner has the audacity of stating that the president of the Law Society was suspended on the 8th of February 2021 by the 2nd to the 10th interested parties. Well, that shows you the disdain, the insubordination with which the petitioner treats elected officials of the society. My Lord, I'm aware you gave an order pertaining to Mercy Wambua, and that is pending before another court. But my Lord, I submit the problem at the Law Society is simple. The individuals holding office in Secretariat believe erroneously that elected leaders are subordinate to them. It can't happen. The Deputy Registrar cannot say that the judge is subordinate to her or him. The CRJ can never say that the Chief Justice is subordinate to her. We saw what happened when my friend Gladys Sholay attempted to do such a thing. It can't happen. It's as simple as that, my Lord. However much they play to emotions, that is the fact. The Secretariat performs the functions of the bureaucracy of any entity. Elected leaders determine policy and implement it. And this has been done since 1943. It cannot change because Nelson Havi is the president. No. My Lord, let me put legal evidence to this argument. I will start with the case appearing as number 7 in my list, a Major Zelemoi versus County Assembly of Baringo. And my lord, the relevant part in this decision shall be found at page 37. And the ratio decidendi here is this. Nobody has a right to has a proprietary right to office. My 3 colleagues insisted that the petitioner is not a public office holder. Yes, she holds a contract of service, which between a public office and a contractual office has great entrenchment. It's obvious, the public office. But here the court has said, you don't have proprietary rights. Well, Lord, let me progress. Let's look at the case of, sorry, my lord, the case we're referring to is Attorney General versus Andrew Kiplimo. Attorney General versus Andrew Kiplimo. That is where that ratio was founded. Now the next case is Amenja Zelemoi versus County Assembly of Baringo. And my lord, you will find the holding here at page 59. And without taking so much of the court's time, I'll just read one line at page 59, last paragraph. Having been removed from office, the court cannot order reinstatement as prayed, because, as guided by the Court of Appeal decision in Attorney General versus Kiplimo, there is no property in public office. And for the same reason, there can be no damages or compensation for monies in form of allowances lost by the petitioner from the time of removal as prayed. So that, my lord, whereas it has not been alleged that money will not compensate this injury, this is an injury which, if proved, can be compensated by money. My lord, still on that premise, I heard Mr. Theory submitting as follows, and he was categorical. The petitioner was summarily dismissed. Then what is the effect of these orders? My lord, these orders are intended to reinstate the petitioner to office at an interlocutory stage. Onyango proceeded to state further that the petitioner is in office working. My lord, I haven't been there since the day they arrested me. So I don't know what's happening there. But if she's there, she's a trespasser. She cannot be in court challenging a summary dismissal and again be in office. It speaks to the conduct of the petitioner. To the petitioner, the elected leadership of the Law Society is non-existent. My lord, but what is the law on this matter insofar as an order tantamount to reinstatement is concerned? My lord, let me pick 2 decisions on that issue. The first of these decisions is the case appearing as number Number 9 on my list, Rift Valley Railways Workers Union versus Kenya Railways Corporation. My Lord, you will find the relevant holding at page 71. I've highlighted it. And this is what 71 says. Page 71, highlighted 1, 2, 3, paragraph 3. The employer was able to show that it genuinely believed that there were reasonable grounds and sufficient grounds to suspect that the respondents had committed gross misconduct in their employment and had done acts which were substantially detrimental to KRA. It is not for the court to substitute its own reasonable grounds for those of the employer. My Lord, the employer of the petition is the Law Society of Kenya. The employer said she's guilty of misconduct. She has insubordinated herself. She's out of office. If the employer is proved wrong at the trial, then it's then that the court may order reinstatement. It is then that the court may award damages. An interlocutory application cannot be the forum for employees who do not want to work, who do not want to take orders, to remain in office. I've been employed twice. I take command. It's as simple as that. My Lord, the second last decision on that point is the case of the Chief Justice versus Brian Madila Haemba. I argued this case on behalf of Honorable Haemba. We got an order before the High Court reinstating him. The Court of Appeal said no. You will find the holding at page 84. And perhaps just 2 lines from the decision of the Court of Appeal will suffice. Page 84, paragraph 12. Concerning reinstatement, the court said, this is of concern as the position held by the respondent involves exercise of judicial power and authority and judicial pronouncement that are made in the period before the appeal is heard and determined may be brought to question in the event that the appeal is successful. Hook, line, and sinker. The petitioner is in charge of ethics and compliance. Her work was until 9th of July to determine whether a complaint against an advocate should be forwarded to the advocate disciplinary committee. How? How do we entrust her with that job? Pending the hearing and determination of the case. My Lord, the last decision on this point is the one appearing as number 11, Irene Itoto Echakara versus Law Society. Irene Itoto was an employee of the Law Society. We fired her last year for insubordination. My counsel fired her. I signed the resolution. When she went to court, this is what your brother Justice Matthew Duma said. And my Lord, you will find this at page 87. Page 87, paragraph 9 and 10. Let me read paragraph 9 and 10. In the present suit, and without preempting determination of facts on the merits, it is apparent that the applicant is no longer in the employment of the respondent, and the court shall have to deal with the factual question whether or not the determination of employment of the claimant was unlawful. Paragraph 10, an interim injunction at this point will amount to an order for reinstatement when the lawfulness or otherwise of the termination has not been conclusively determined. Well, that's the position. the petitioner and the interested parties told you that we'll argue this issue on the balance of convenience. We will not. There is no need to argue balance of convenience. That will be leapfrogging. There is no prima facie case. There is no claim or demonstrable evidence that damages will not be an adequate remedy. My Lord, lastly, there is this issue that Mr. Theuri dwelt upon at length. It was Mr. Theuri's submission, my Lord, that the Law Society has brought itself to ridicule and shame, that the Law Society disobeyed a court order, and that for that reason, the court must take drastic measures to remedy the situation. My Lord, is that so? This is the starting point. My Lord, in the motion dated 19th July, an order was sought under prayer 4 specific to restrain the recruitment of an individual to take over from the petitioner. A specific order. And because this is significant, my Lord, permit me to read that prayer. That pending the inter partes hearing and determination of the application herein, the respondents, and especially the first and second respondents, be restrained from interfering with her role as Deputy Secretary, continue harassing, bullying, and intimidating her, or forcibly remove her from her workstation, fail to pay her salary and benefits as senior LSK Secretariat and staff, and this is important, my Lord, or replace her entirely from her current position as Deputy Secretary and Director of Compliance and Ethics, or from withholding a salary or withdrawing any privileges. That is prayer 4. Lord, in the decision made by your sister on 19th of July 2021, that prayer was not granted. And my Lord, it's important that we say this, because somebody cannot go lamenting everywhere of disobedience, yet there is no order that was disobeyed. My Lord, the order that was granted by your sister read as follows: that there shall be a stay of the decision inviting applications for the position of Director of Compliance in terms of prayer 3 of the application, pending inter partes hearing of this application. My Lord, parties should not blame the court or the adversaries for events that are not caused by the court or the adversaries. And this is why. My Lord, the notice inviting applications for the office formerly held by the petitioner was signed by myself on 12th July 2021. It was put in the Daily Nation on the 13th of July 2021. You'll find this at page 216 of the exhibits of the affidavit of the petitioner. When did they go to court? They went to court on 19th. A clear 6 days after. Now, Lord, the notice indicated that the close of applications will be on 20th July. They sought to stay a notice that had taken effect. It's not my problem. Neither can I blame the judge for refusing to give prayer 4. My Lord, but more fundamentally, what is before you is the consideration of the notice of motion dated 19th, 2021. There is no application for contempt before you. I believe, and I know my learned friend, Mr. Eric Theuri, is well learned. I believe if he was certain there was contempt, there would have been before you a contempt application. So, my Lord, determine the application before you. There is no contempt application before you. My Lord, in conclusion, permit me to say this. The Law Society of Kenya plays a fundamental role as given to it under Section 4 of the Law Society of Kenya Act. That role cannot be effectively undertaken by the elected leadership if the Secretariat is hell-bent on undermining the work of elected leaders. It's as simple as that. And for this, I have no apologies to make. An elected leader has 2 years to do work. What has happened here is the Secretariat commencing with the second interested party undermining the work of elected leaders. It can't happen. They either choose to work in the Secretariat or put their names on the ballot. If you are a secretary, you are a secretary. You're not the president. You're not the vice president. And I plead with the court not to allow its processes to be abused by employees who are paid from our monies and do not want to work. My Lord, humbly pray that you dismiss this application with costs. And the costs are imperative for the reason that, one, these prayers, 5, 6, and 7 are already spent. We've recruited. And two, this is a petitioner who has decided not to sue her employer, but to sue the vice president and myself. If she thought we didn't have power to do what we are doing, why did she sue us? If our action was a nullity, why the claim of summary dismissal? My Lord, this should not be countenanced. The employment court is there to protect the rights of employees, but it's also there to protect the rights of the employer. My Lord, I believe I've done justice to this matter. Permit me to rest.
Mr. Theuri, you able to respond?
Yes, my Lord, I will make some very brief responses.
Yeah.
My Lord, the first issue we want to raise with the submissions that have been made by the President is that there is a mischaracterization of the petitioner's case before you. My Lord, it is not that the petitioner is saying that she is not answerable to the President, the Vice President, or the Council. The petitioner is simply alleging that for proper corporate governance and respect to the chain of command, she should take her instructions from the secretary.